Good afternoon, everyone. As Keith said, this program is meant to help parents, caretakers, and advocates understand what are some of the major reasons for chronic absences in New Jersey and their potential impact on student achievement. Important attendance laws to know about that students must comply with, and how parents can advocate regarding attendance issues. There are some misconceptions about how attendance laws impact children. For example, some parents may think that absences during the early years, but educators and experts agree that daily attendance is important at any grade. Another misconception is that as long as an absence is excused, there are no negative consequences. I hope this presentation provides clarity regarding these misconceptions and other attendance issues. So the latest New Jersey Department of Education chronic absenteeism data is from 2022-2023 school year. This data is available on the NJDOE website and demonstrates, in addition to an increase in absenteeism from pre-pandemic levels, huge differences between specific groups of students, depending upon their race, ethnicity, or special circumstances. While the statewide average in 2022-2023 was 16.6%, Asian, Native American, or Pacific Islanders were absent at a rate of 8.7%. White students were absent at a rate of 12.9%. However, Hispanic, Black, or African American students, as well as students identifying as non-binary or undesignated gender, economically disadvantaged students, students with disabilities, or in foster care were all absent at a rate of well over 20%. This data suggests that there are complex reasons why students are absent and have to do with factors both relating to how schools address academic and social emotional issues and to factors relating to what students are experiencing outside of school. So according to the calls that ACNJ receives from parents requesting assistance with school issues, there are several common reasons why children miss school. Health issues, anxiety, depression, busing and transportation issues, fears of attending school because of bullying or violence, loss of interest in school due to unaddressed academic or behavior issues, or frequently being suspended or reprimanded by teachers and administrators, which leads to motivation to go to school. Based on experience helping parents advocate for their children's education rights, one way that has proven effective in reducing the impact of these factors on a child's attendance is when a parent knows their rights, are able to access resources out of school, and know how to ask for appropriate services and when to contact an advocate for assistance. So between the 2021 and 2022 school year and 2022-2023 school years, incidents of bullying, violence, and suspensions rose from 36,791 to 44,262. This is according to data reported by northjersey.com in April 2024. And we have a link to this and also the New Jersey Department of Education data I mentioned before on the resource page of this presentation. The increase in incidents reported in this article is certainly troubling and is consistent with information we receive from parents as to some of the reasons children don't attend school. A potential reason for the rise of student absenteeism coinciding with increase in suspension, bullying, and violence is that if a school isn't addressing the underlying reasons for bullying, violence, and behaviors that lead to suspensions, school staff may not be engaging students and families in a way that promotes a positive school environment, and with that, good attendance and ultimately academic achievement. So, for example, if a student is repeatedly suspended from school and thus misses several days of instruction, the student may lose the opportunity to learn critical skills, may then fall behind, which can lead to things like loss of self-esteem, loss of motivation, as well as putting the student at risk for other unhealthy behaviors, including missing additional days of school. Now, attendance rules are governed by New Jersey statutes and regulations. So, by law, a school year must consist of at least 180 days of instruction. However, individual districts may establish a longer school year. Schools are required to keep attendance and report attendance data to the New Jersey Department of Education. Parents in New Jersey are required to send their children to school between the ages of 6 and 16. This is known as compulsory education. This law applies to students in public schools, although a parent who withdraws their child from school and fails to educate their child could be charged with education neglect. So this is a New Jersey law regarding compulsory education. In New Jersey, students may be absent for up to 18 days without facing consequences such as failing a class or retention, and can be absent even fewer days to run the risk of truancy. However, this 18 days is the maximum allowable absences according to the New Jersey Department of Education, but individual districts can permit even less annual absences. Districts may make exceptions to its attendance rules for a particular student under special circumstances. In addition, the laws governing the education of students with disabilities allow for accommodations that could include a waiver of attendance rules if it can be established that this accommodation is necessary for the student to progress toward their academic goals given their disability. Generally, though, it is difficult to establish that a student should be granted a waiver of an attendance rule. Schools also must establish policies regarding excused absences, written policies that align with the state laws. Aside from certain statewide approved religious holidays and other state-approved absences, for example, for college tours, other excused absences, as well as the criteria for when an absence will be excused, are determined by the individual districts. Here are some other important attendance laws. A length of school day is considered at least 4 hours for a student to be considered present in school, or if the student is in kindergarten, between 2 and 2.5 hours. Anytime a student is receiving home instruction through the school, this counts as a day of attendance. In terms of tardiness, school districts determine how late a student can be without being marked tardy or absent. In addition, districts may determine how excessive tardiness to school or a particular class can result in a determination that the student was absent. As mentioned, schools must have written code of conduct and written school board policies, and this will also include the attendance rules and rules regarding lateness, consequences, and appeal rights. These rules have to be consistent with New Jersey education laws, but can vary depending upon the district, as long as they comply with the New Jersey laws. Usually, the code of conduct will be on the district's website. Schools should provide parents with a copy of the code of conduct at the beginning of each year, and schools have to make provisions for parents who require a paper copy or translations. Also, parents should have access to their school district's Board of Education policies, which are also typically available on their district's website, but a copy could be requested through their Board of Education. Because each district does have discretion to establish their own rules as long as they comply with the New Jersey Department of Education, each parent should familiarize themselves with their child's code of conduct and district policies regarding attendance, and in general, all rules. Parents and students are held to be knowledgeable about these rules. And on the resource page, there is a link to relevant attendance statutes and regulations that are also available on the New Jersey Department of Education's website. Now, talking about some ways that school staff can respond to absences. There are a range of ways that schools, by law, according to the New Jersey regulations, are supposed to address unexcused absences. And there are specific, education laws for how they respond. A district's code of conduct and school board policy will also describe the criteria for an absence to be excused and the process that the parent should use to get an absence excused. So from anywhere from 1 to 4 unexcused absences, and the New Jersey Department of Education guidance suggests that schools should immediately respond as to the first unexcused absence. This can include interviewing the student and parent at a meeting to determine what is the reason for the absences. For example, it could be that the parent didn't know how to correctly get an excused absence. Maybe they didn't understand that you have to provide a written letter from a physician, or maybe there's an underlying problem in the school that needs to be addressed. Perhaps the student has a chronic health condition and the parent doesn't know where to get help in the community, so that the parent may need some kind of referral information. Maybe it's a combination of issues. School staff are supposed to develop a plan with the parent to improve attendance, which could, for example, involve some kind of weekly check-in, maybe addressing a bullying issue or a peer conflict issue, an academic issue, or whatever the issue is as appropriate. The school can also contact the Division of the Department of Children and Families if they suspect abuse or neglect, and law enforcement as appropriate. For between 4 and 9 cumulative unexcused absences in the school year, in addition to the steps I mentioned above, a school team should meet with the parent and child again and review the plan that was put in place to see if either it wasn't being implemented or it wasn't effective, and develop a new action plan as needed. At this point, because 4 to 9 unexcused absences is considered serious, the staff should consider, along with the parent, whether intervention and referral services are needed or whether there should be a referral to the child study team for evaluations. Schools could also consider, if it's determined that the main reason for the absences is the school setting, they can consider an alternative placement together with the parent. So for 10 or more unexcused absences, in addition to the range of interventions I mentioned before, a school can consider truancy. And these are for students between the ages of 6 and 16 years old when there's compulsory education. Truancy charges will be brought in the municipal court. It's against the parent. It could entail periodic court dates until the attendance issue is resolved. It can result in potential fines to the parent, and again, the Department of Children and Families can be contacted if abuse or neglect is suspected. Parents can always challenge the truancy charge. First of all, truancy can't be brought for excused absences, so parents should look through their records and, if applicable, provide the school with copies of the letters previously provided, for example, doctor's notes or other documentation as per their district's rules about establishing an excused absence. If the parent believes that the school district did not provide the positive interventions or did not provide them in a way that was effective, one way that a parent can challenge the truancy charge is to contact the school administrator. This could be the attendance officer and a principal or superintendent, and if applicable, the child study team or 504 team or the IRNS team, and include them in communications regarding the truancy to challenge it. They should request a meeting. The parent should request a meeting in writing to come up with a plan to help correct the attendance issue. Now, as per regulations, school staff have an independent obligation, even if the parent doesn't know how to access services from the school, to continue to provide positive supports to the student even after a truancy charge is filed, such as involving the child study team or 504 team if applicable, and to continue to identify reasons for the absences, to collaborate with the parent and treating physicians, if any, consider evaluations, ascertain what academic and behavior supports are needed, such as, does the student have a potential disability that necessitates initial evaluations, or if they do have a disability, or other evaluations, or is it necessary to revise the current IEP or 504 plan. At the same time, they should be coming up with a credit recovery plan with the student and parent. Parents should consider consulting with an advocate when truancy charges are filed, and should be prepared to go to court with any evidence that supports their challenge to the truancy charge. Usually, if a parent can demonstrate that they are trying to make steps to improve the attendance, they are unlikely to get fined, but the case may still stay open until the attendance issue is remedied. In these kinds of cases, parents should consider getting counseling services for their child and should be maintaining copies of records of their efforts to get the school staff to help their efforts to have the school conduct meetings and to schedule meetings and to and throughout the truancy case, parents and school staff should continue to work together. Unfortunately, some municipal court judges may not fully be aware of the school's role in promoting daily attendance and may side with the district that is pursuing truancy. And because every case is very different and depends upon the facts, if the truancy case isn't closed, this is a time when consulting with an advocate could be a good idea. So without prior written agreement regarding how school will be made up and credits earned, students with excessive, excused, or unexcused absences are at risk for the following consequences: a failing grade, retention. The school district may disenroll a student. Of course, the student can always re-enroll. That's important to know. Students may be at risk for wanting to drop out from school because of loss of motivation or being pressured to drop out by school staff. This can also cause delay in high school graduation when students have to retake classes or repeat a year or more. And regarding retention and promotion is at the discretion of the school administrator. In addition, teachers have the discretion to determine whether or not a student has passed a class or not. However, parents can appeal both a failing grade as well as retention. Best thing for a parent to do if their child is having excessive absences is to meet with relevant school staff as soon as possible in the school year and try to enter into an agreement or get written confirmation from a school administrator and teachers regarding how schoolwork will be made up. Regarding dropping out of school, I hear that some schools, districts, particularly if the student is 16 years or older, may try to encourage a student who has missed a lot of school to withdraw from school, or may take this student off the rolls, which means to disenroll the student. I also hear from parents who want to take their children out of school when truancy charges are filed against them because of they don't want to keep on battling the school. In all of these cases, when the student is no longer enrolled in school, the parent can always re-enroll the student. And the ways in which parents can appeal these consequences will be discussed in an upcoming slide. So some students are absent because of a temporary or chronic health condition, including a mental health condition. There is a specific process that parents should use to get these absences excused and to get the school to provide instruction, which is critical to reduce absences to count towards attendance during the period of illness. When a student has a temporary or chronic health condition, parents should provide a qualified physician's letter to excuse the absences and at the same time request home instruction. Because as I stated before, home instruction counts as attendance. The letter from the physician should include the diagnosis and the basis for the diagnosis, by which I mean the testing that the physician used to reach the diagnosis, a statement from the professional that it is anticipated that the student will be out of school for more than 10 consecutive or 20 or more cumulative school days, and state the reasons why. So, for example, some students will have severe depression, and through experience, it's noted that the student may not, be able to leave the home, and the doctor can then sort of anticipate because of the behavior that the student has, the difficulties that the student has experienced, and that it's likely the student's going to miss more than 20 school days during the school year because they just simply can't get out of bed or leave the home. In that case, the doctor would, make that statement, and then as a result of which, recommend and request that the student be approved for home instruction, as well as, as necessary, appropriate modifications to classwork, homework. Sometimes an agreement can be reached, or the doctor's going to recommend that there's a modified schedule so that the student receives home instruction for part of the day while the school still works to encourage the student to come to school. This letter should be sent by the parent to the school nurse and the principal, and parents, I advise them to retain copies of the letters for their records. Once the letter is provided to the school nurse, it's referred to the school physician. Every school contracts with a physician, and one of their jobs is to review these requests for home instruction. And once the physician makes a decision, the parents are entitled to notice of the decision within 5 days of the decision. And parents can appeal a denial. I have here for your reference the New Jersey Administrative Code section regarding these circumstances. Other things that parents should know about this particular regulation is that a school physician could ask to speak to the treating physician for further clarity. The parent would have to provide written consent for this. And if the home instruction is denied, the school physician should state the reason. This notice should be provided to the parent. Since the pandemic, I just want to mention mental health issues in children of all ages has been on the rise. I think that's been fairly reported in the news, causing children to miss school days either because they refuse to go to school or because school staff require them to leave school and stay home when the school alleges the student is a danger to themselves or others. There are laws governing when and how schools can keep a child out of school. In these cases, students are entitled to instruction just as if they were suspended, and parents can also challenge the school district's determination to keep their child from attending school. It's a complex area not being covered in this presentation. However, for anyone that is interested, there is information available regarding mental health issues and student rights on ACNJ's Students' Rights page, as well as on the Department of Education website. Now, when due to a chronic health issue, a student is approved for home instruction, this should be provided within 5 days of approval. And if the student has an IEP or a 504 plan, the services should be aligned with those plans. When a student will be out of school for more than 5 days due to being excluded by school for a mental health reason, the student must also receive instruction upon the 5th day being removed from school. In either scenario, services could be in person or online if appropriate. A certified teacher is required. Instruction according to the code should be sufficient for the student to continue to progress. However, parents can try to argue for 10 hours of instruction if the school doesn't offer this amount. In addition, an adult must be present at the time of instruction, which usually will take place after the school day, although it can take place during the school day if the school and the parent reach an agreement regarding that. It'll usually take place in the student's home or another agreed upon place. Appealing a denial of home instruction request due to a chronic condition can be made to the Commissioner of Education. However, parents should really try to appeal this first through an administrator, such as the superintendent or the director of special education if applicable. When appealing a denial of home instruction, one step a parent can take is to try to find out from the school what other evidence they are looking for to support the request for home instruction. And of course, any other ideas the school has to implement a plan to improve attendance. Parents wanting to appeal a school decision to remove a student from school should also consider contacting an advocate. So in discussing how to advocate for services to address excessive absences, For general education students, parents can consider requesting intervention referral services, which can be initiated by a parent's written request to the IRNS team for a meeting to come up with an IRNS plan. Every school has an IRNS team, and so the best thing to do would be to write to the principal to find out who that team is. Sometimes the principal is on the team, sometimes it's a guidance counselor. No formal evaluations are needed for these services, just evidence that the student is demonstrating academic or behavior issues, which includes excessive absences. If the student doesn't have an IEP or a 504 plan, but a disability is suspected, parent can consider writing to the child study team for evaluations. For either a 504 plan or an IEP, parents can, but do not have to provide schools with evaluation reports. As the school is responsible to evaluate students who are suspected of having a disability that is impacting the student in school at no cost to the parent, and this is under both state and federal laws. So when trying to address an issue of excessive absences, the first thing parents should do is to make sure that they are keeping track of exactly when the student is absent, and again, just keeping a record of notes provided to the school. Some students accumulate absences after being tardy a number of days or arriving to school after attendance is taken. For suspensions or when students otherwise bar students from attending school, students will be considered absent until they receive home instruction. Students are not permitted to attend, however, but home instruction should be provided upon the 5th day. So if it's not provided upon the 5th day, parents should challenge that and contact an administrator immediately. And home instruction should be made up if it wasn't timely provided. Students who are not permitted to attend school, whether or not their absence is excused or not, should be given the opportunity to make up schoolwork. And in order to start advocating regarding an attendance issue, parents should first write to the principal to obtain a copy of the child's attendance record. And if the attendance record is incorrect, parents should immediately write to the principal to challenge the attendance record. If schools aren't complying with attendance laws, including not providing home instruction that is the student is entitled to, parents can write to the school but can also consider contacting an education advocate. If the parent suspects that the absences may be due to behavior issues and the student doesn't have a disability, as I said, there's a variety of services that are available in the school. And the parents should, again, it's best to try to address the absences as soon as they become problematic and not wait for the school year to, not wait too long into the school year to try to address these issues. But parents do have the right to notice when their child is struggling academically or at risk of retention due to absences, and have the right to progress reports and grades. At school meetings, parents have the right to have their input considered regarding why their child is missing school and/or classes. However, it's very important to know that even if there is a good reason for why a child missed school, if there are too many absences and steps weren't taken in advance to arrange for alternative instruction, the school may have the right to retain the student if there isn't time to make up the instruction before the next school year. For example, some students whose parents have contacted me have missed 30 or more days of school and have failed multiple classes, and it's hard to make that time up before the next year's, because usually, the options for making up classes are summer classes, online classes, maybe tutoring if appropriate, modified assignments, home instruction, after school and weekend instruction. But if the parent only realizes that this is an issue in the spring of the school year, depending upon how substantial the work loss is, how much the student has to make up, it may not be practical for the student to complete the work. Parents students who fail a class for missing more than the allowable time permitted to miss a class, or have accumulated absences for being too late for class based upon the school written policies, can try to appeal the failing grade through an agreement with the school teacher regarding how to make up the work. And if the school teacher isn't responsive to the parent's request, this can then be appealed to the principal. And even, the superintendent or the Board of Education. For children who are in special education or who could be eligible for special education, and when the absences are related to the student's disability or yet to be identified disability through evaluations, the parent should request a meeting in writing with the child study team to discuss the potential evaluations that could be conducted, or how the IEP could be, or 504 plan as applicable, could be modified. When a parent wants to challenge a retention due to absences for a child with an IEP, the parent should request a meeting with the child study team in writing to see what the options are. So while students with disabilities are entitled to learn with their same age peers, which is the reason to promote the student with an IEP, the parent should ask the child study team how instruction will be made up if the student has had too many absences and if the student will be promoted. So in high school, there are other considerations. New Jersey laws require districts to provide students with a variety of ways to achieve their high school graduation requirements. But in high school, there is a minimum amount of high school credits students have to earn. That's at least 120 credits in New Jersey. And there are also requirements regarding how many years of each subject is needed in order for the student to earn a diploma. Students can withdraw from school only with parent written consent unless they are 18 or over. And again, students may re-enroll at any time until the age of 20 for a general education student, or age 21 for students with an IEP. In addition to all the variety of ways that schools are supposed to offer to students to complete their high school diploma if they have lost credits because of attendance issues, students can also obtain a state diploma through a GED. And there are various community programs available to assist a student to pass the GED and gain other skills, but may require fees and other conditions. So it's important for parents and students to gather information to understand whether a GED is a good option. For students who don't have a learning disability and only who are, aren't very behind in credits, it may be a good option. But if a student, has missed, more than 2 years worth of high school, it may be challenging to pass the GED, and that's when a parent should consider consulting an advocate to understand what all the options are. Some schools, in some cases, the school might be responsible to pay for additional instructional services for the student if they haven't complied with their requirements to meet the student's needs. This is for general education students, but also for students with in special education. They are entitled to additional rights in addition to being able to be in school until the age of 21. They are supposed to be provided with transition services, which are those services that they need to prepare them for life after high school. And this may entitle the student to additional education services to help them not only earn their high school degree, but also to earn it after, to continue in school after 12 years. Many schools offer summer school programs free of charge. Some districts who don't run a summer school program for all their students may then require the parent to pay a fee. If schools do provide summer school courses for a fee, parents who can't afford those courses because they don't have the financial ability to, may be entitled to a waiver of those fees. And again, parents can also consider contacting an advocate if they have concerns regarding how the high school attendance issues and how school staff are addressing the loss of credits. And finally, here are resources that we've included for you. The attendance laws as per the Department of Education, and other resources, information from our students' education rights regarding various special education rights, bullying rights, discipline rights, and other issues, and the data and bullying data that we cited. Any parent is always free to contact me for assistance, and my information is here. And now if anybody has any questions, I'm happy to try to answer them.